Hello, welcome everyone. Welcome to another postdoc webinar. My name is Lorena Real. I am a postdoc at FAU at the Brain Institute. And if you've been to one of our webinars in the past, you've probably seen me. I've been the host for these webinars for the past year. That's because I have also been during 2020 the president of FAU's Postdoc Association. In the beginning of this year, however, we did switch our board, our executive board for the Postdoc Association, and we have a new president, and he's also going to be taking over these talks. So just before I introduce him, just very quickly, I would like to thank all of you, everyone that has attended in the past. I really hope that these talks have helped some of you in any way. And also, again, thank the people that helped making this happen throughout the last year and then helped us, Jenny, Cami, Gina, and Karen. So with that, I would like to introduce David Bradshaw. David is a postdoc at FAU at Harbor Branch, and he is the new president, and he's going to be your host from now on.
Thanks, Lorena. And thank you all for joining us today. So like Lorena said, I'll be the host for the rest of the series this year. And the series was co-created this was a co-creation between FAU's Postdoctoral Association and the Office of Postdoctoral Affairs. And Dana Vogelaitis is our speaker for today. She is the Assistant Director of the Office of Technological Development, which is part of the Division of Research at FAU. She has served the university in this role for over 4 years. Prior to FAU, Dana worked as an in-house attorney advising on intellectual property matters at the Florida Institute of Commercialization of Public Research in Boca Raton and at the Niken Center for Performing Arts in New York City. She is licensed to practice law in Florida, New York, and New Jersey, and is a certified licensing professional. Thank you for joining us today, Dana.
Thank you so much for having me. Good afternoon, everyone. Thank you for attending. I hope you're all staying safe and healthy. Just bear with me 1 minute while I share my screen with you. All right, so today I'm going to be talking to you about protecting your ideas. And by that, I mean intellectual property. And I think this is a topic that, regardless of where your career after being a postdoc takes you, whether you remain in academia or you go on to industry, I think it's a topic that will inevitably come up for you. And so I hope the information you learn today is valuable. So here's just an outline of what I plan to discuss with you. I'll introduce you to my office at FAU, discuss the different types of intellectual property protection that are available, the importance of protecting that intellectual property, and then also talk about some careers in intellectual property that you may be interested in. And then I'll give you some resources if you'd like some additional information. So first, I'll introduce you to my office, the Office of Technology Development. Right now, we're a small team. I basically run the office, and I work with Regina Thompson, who is the Strategic and Economic Initiatives Manager in the Division of Research at FAU. So while she doesn't work directly for the office, I interact with her a lot. She helps interface with faculty members and students, finds out what research areas they're interested in and working on, and we collaborate to help protect any intellectual property that comes out of that research. So my office has 2 primary goals. The first is obtaining legal protection for any intellectual property that emanates from university research. And second is commercializing that intellectual property, typically through license agreement or sponsored research. And that could be with a large established company or a small startup company. Could even be a company you start yourself. So now I'd like to take you through a brief overview of the different kinds of intellectual property. So there's 4 main types of intellectual property: patents, copyrights, trademarks, and trade secrets. The first three you routinely encounter in an academic environment such as FAU or another university. The fourth one, trade secrets, doesn't really come up in the university context, and I'll explain why when I get to it, but that's just another one that you should be aware of. So let's start with patents. So a patent protects new or improved processes, machines, articles of manufacture, or compositions of matter. Typically inventions created in the scientific or technical disciplines, but it does not protect things like laws of nature, physical phenomena, abstract ideas, or any information that's already in the public domain. And the purpose behind a patent is that it gives them an exclusionary right, a right to prevent other people from doing something. So if you have a patent, you can prevent others from making, using, selling, marketing, importing the invention within the United States or the country where you have patent protection. So let's take a look at some of the requirements to obtain a patent. First, obviously, it has to be new. It has to be different from what already exists, what's already been invented. Second, it has to be useful. It has to have real world value. It has to have utility and serve some sort of purpose. Third, it has to be non-obvious. It can't be an obvious idea to someone who works in the field of the invention. So if you work as a mechanical engineer, let's say, if someone in that field with the same level of education and expertise as yourself would be able to think of this solution off the top of your head, then it's probably an obvious invention and not something that would be able to get patent protection. And finally, the invention can't be publicly disclosed. You cannot have used it publicly, published, sold it, anything along those lines for more than 1 year before you file a patent application, or you will not be able to obtain protection. And I always like to elaborate a little bit on the last requirement, public disclosure, because it's something that my office sees a lot and gets a lot of questions about. So in the university setting, a public disclosure could include things like your research paper, a grant abstract you submit, a conference speech that you give, a poster presentation, or even a peer discussion. And as a caveat, I should mention that all of these things, if done within the FAU community, if you're an FAU student, don't count as a public disclosure. It's once you go outside FAU that this becomes an issue. So if you give a presentation at a conference outside of FAU, then that would be a public disclosure. But if you're just talking to your peers within FAU, giving an internal FAU presentation, it probably won't be an issue. So let's take a look at the patent application process. The first step in the process is, of course, to invent something. So through your research, you conceive an invention. Then, if you're interested in patent protection, you would work with a patent attorney or patent agent to draft the application. And depending on the nature and complexity of the invention, that process can take as short as a couple of weeks, or it could take a couple of months typically. And the patent application is broken up into two main parts. The first would be the description of the invention, how it works, how someone would use it. And the second most important part is the claims, which is the legal description of the invention. And the patent practitioner would work with you in such a way to structure the wording of these claims to make sure you're getting the maximum amount of protection for your invention. So once you've drafted the application, then the patent attorney or patent agent would file the application with the relevant patent office. Typically at FAU, we file mostly in the United States, but sometimes there are circumstances that warrant international protection, and there's a whole separate process for that. So when you file an application, there's really three different kinds of applications you could be talking about. The first is called a provisional patent application. And that's really just a placeholder. It allows you to publish, present, talk to companies, do things you normally wouldn't be able to do. But with the provisional patent application, you are protected for a period of 1 year. That being said, that's the extent of the protection that that application provides you. After 1 year, it expires. So a few months before the expiration of a provisional patent application, I'll work with the inventors and decide if we want to file what's called a non-provisional application, which is the application that's actually examined by the patent office and can mature into an issued patent. Typically that has a little bit more information, might take a little bit more time to draft, costs a little bit more money. So those are the two main options. And of course, you always have the option to go directly to a non-provisional and skip the provisional stage. And then, as I mentioned previously, if you're interested in international patent protection, you can file what's known as a PCT, or Patent Cooperation Treaty application. And that would start the process if you're interested in protecting your invention in countries outside of the United States. All right, so you filed your application, one of those three, and then the waiting game begins. It typically takes, right now, I think about 18 months for the US Patent Office to respond to a filed patent application. And that's just because of the caseload that they have right now on their dockets. But typically when they do respond, it's in one of two ways. The first is that they could respond with a notice of allowance, which is basically the patent office saying, congratulations, we're going to issue you a patent. It's very rare that that would be the first communication you would get from the patent office. Typically what happens instead is that you'll receive what's known as an office action. And an office action is the patent examiner's way of stating their objections to your application, what might be wrong with it, what you might have to change about it, things of that nature. So that starts the part of the process known as patent prosecution. And it's basically back and forth communication between you with your patent attorney or patent agent and the patent office to resolve these objections that they have to your application. Hopefully at the end of that, the patent examiner will allow the application and you'll receive an issued patent. And patent protection typically lasts for 20 years from the date you filed the application. And I just want to include some real world examples for you guys that you may have heard of in the news. So one that relates to patents is the so-called smartphone wars between Apple and Samsung. So in 2011, Apple filed a lawsuit against Samsung for infringing patents it held on various software and hardware elements of its smartphone. And at the trial, the jury awarded Apple $1 billion in damages. Of course, Samsung appealed the jury award. They didn't want to pay that. And in 2016, the US Supreme Court found in Samsung's favor and actually remanded the case to the lower court for a retrial. Then we get to retrial in 2018, and the jury awarded Apple only $539 million in damages, slightly better. But Samsung indicated it would appeal this decision, but before it could get to an appeal, the parties reached a confidential settlement for an undisclosed amount of money. So we don't really know how much Samsung ended up paying in damages to Apple. And this is just an example. I found this image interesting of what Samsung phones looked like before the iPhone and what their tablets looked like before the iPad. And then once the iPhone and the iPad came out, how much more similar you could say Samsung's products started to look to Apple's products. So it's just an interesting piece of case law that I thought you would enjoy. So let's move on to copyrights. So a copyright is different from a patent. It doesn't protect scientific or technical works. It protects creative works, things like books, music, plays, choreography, photographs, paintings, sculptures, movies, and even architecture. And it doesn't protect the idea itself. It only protects the creative expression of the idea. And unlike patents, which I told you were an exclusionary right, copyright is actually an affirmative right. It gives the copyright owner specific rights to do things. So if you're the copyright owner, you have the right to reproduce your work, distribute your work, publicly display your work, and publicly perform your work. So the requirements to obtain a copyright are much simpler than patent. First, the work just has to be original. You have to be the one that conceived of it. You can't have copied it from someone else. And it has to be fixed in a tangible medium of expression. And basically what that means is that it's written down either in hard copy or electronically. So the copyright registration process is a little bit more simple than the patent process. First, you should note that it's an optional process. Copyright protection is actually automatic as soon as you create the work and it's fixed in a tangible medium of expression. You really don't have to do anything more. But I always advise most of the students and the faculty members that come to my office that copyright registration is a good idea because it enhances your legal rights. It provides a legal presumption that your copyright is valid. It puts the public on notice that you're enforcing your copyright, and it allows you to sue for infringement in federal court and collect damages if that ever became an issue. So if you want to register your copyright, you would fill out the registration application. You can work with a copyright attorney to do that and file it with the relevant office, whether that's in the United States or abroad. And it's a short process, can be done in a matter of days. And then after that, it probably takes, I'd say, about 3 months for the Copyright Office to acknowledge receipt of the application and publish it in a newsletter that they circulate. So the public is officially on notice that you are registering your copyright. And then once it's published, maybe another 3 or so months go by and the registration will issue. There's no prosecution process or back and forth. And once the copyright registration is issued, your copyright will be valid for your life, the life of the author, typically plus 70 years. And that can vary depending on the circumstances under which the work was created. So here's a real world example of copyrights in action. I'm sure you guys know Taylor Swift and the musical group 3LW. So in 2014, Taylor Swift wrote her song Shake It Off, which included the lyrics, "Players gonna play and haters gonna hate." The song was a big success for Swift. It spent 50 weeks atop the Billboard 100 and presumably made her a lot of money. However, 2 songwriters accused Taylor Swift of copyright infringement in 2017 based on a song they had written for the group 3LW back in 2001 that had the lyrics, "Players they gonna play and haters they gonna hate." And they sued Swift over that for $42 million in damages. At trial, the judge dismissed the case because, in his opinion, the lyrics lacked sufficient originality to merit copyright protection. An appeals court ended up overturning that decision, and the case was sent back to the lower court where it currently is now. So here's the lyrics side by side, 3LW's on the right and Taylor Swift's on the left. So the judge that takes this case up on appeal will have to determine if the lyrics on the right are sufficiently original enough to merit copyright protection. And if so, if the lyrics on the left are sufficiently similar to those on the right, that they would be considered infringing. So just another interesting example for you. Now we can move on to trademarks. So a trademark is distinct from patents and copyrights in that it's typically used by businesses, not so much individuals, although it can be in certain cases. And a trademark is used to designate a source of goods or services. It can protect words, designs, sounds, or even colors. Some interesting examples I always like to give are the NBC News chimes. You hear those 3 little chimes when NBC News comes on the air. That's trademarked. And Tiffany Blue, if you're familiar with the jewelry company Tiffany & Company, they have a distinctive blue packaging that all their jewelry comes in, and they have actually trademarked that particular color. So the purpose behind a trademark is that it denotes a standard of quality. It's a physical manifestation of the company's brand identifier. You know when you're buying goods from a certain business that you can expect a certain level of quality from them. And it helps to avoid consumer confusion. It's really designed to protect the consumer. So the requirements to obtain a trademark are pretty straightforward. First, it has to be a strong mark, and the Patent and Trademark Office has a spectrum of what they consider to be a weak mark and what they consider to be a strong mark. So an example of a weak mark would be something like the term escalator. Now, decades ago, all moving staircases were not known as escalators. Escalator was actually a particular company that made moving staircases. So they could have the trademark on that name. However, today, whenever anyone sees a moving staircase, they refer to it as an escalator. So that term has become what the Trademark Office calls genericized, meaning that it no longer distinguishes one moving staircase from another. They're all referred to as escalators. So that's an example of a weak trademark. An example of a strong trademark would be something like the term Nike. So Nike originally was either a Greek or Roman god, I always get it confused, and not something that the average person before Nike, the company, came around would associate with things like shoes and athletic apparel, things of that nature. So the Trademark Office considered Nike to be a strong mark because that association between the word and the goods isn't automatic. You don't think all athletic shoes and apparel belong to Nike. It distinguishes them. The second requirement to obtain a trademark is that there can't be any likelihood of confusion. So there can't be any danger that the consumer is going to confuse the source of goods or services from one company with another. So a good example I like to give of that is there was a trademark case a few years ago where Starbucks sued a mom and pop coffee shop and they were called Charbucks. So obviously Starbucks wasn't too happy that this little coffee shop was trying to profit off of their well-known name. But the court actually determined that there was no likelihood of confusion in that case because an average consumer could distinguish between Charbucks and Starbucks. And then the final requirement to obtain a trademark is that it has to be used in commerce. You have to be actively selling, marketing, importing, exporting goods or services. The trademark registration process is somewhat similar to the copyright registration process in that it's optional, but I typically recommend it because again, it enhances the legal rights that you have. So if you're interested in doing that, you would work with a trademark attorney to file for a trademark registration. That's a pretty straightforward process, maybe take a couple days, couple weeks. And then it would be examined by the Trademark Office. And this is actually where trademarks are more similar to patents in that there is a prosecution process. The Trademark Office can issue an office action with their objections. You can communicate with them back and forth and argue why you should be allowed to get a trademark. And then hopefully at the end of that, the trademark will be issued to you. And you can have trademark protection theoretically forever, as long as you're continuing to use it in commerce. So here's a look at the 10 most valuable trademarks. And these are all names you guys have probably heard before. Google, IBM, GE, Walmart, Vodafone, Apple, Wells Fargo, Microsoft, Bank of America, and AT&T. And these numbers are a couple years old, so the trademarks for these companies are probably even more valuable now. So it just gives you an idea of how much some of the biggest trademarks are worth. Now we'll quickly go through trade secrets, which I mentioned before doesn't typically come up in the academic environment. So a trade secret protects a formula, a practice, a process, a design, instrument, pattern, method, or compilation of information that's not known to the public. And the only requirement for a trade secret is to use reasonable efforts to, you guessed it, keep it secret. And the idea behind trade secrets is that it's supposed to give the owner an economic advantage over their competitors. If nobody knows your formula to doing something, they can't compete with you. So here's a look at some of the 10 most famous trade secrets. Formula for Google, recipe for Big Mac sauce, the formula for determining the New York Times bestsellers list, formula for Listerine, the recipe for Kentucky Fried Chicken, a recipe for Twinkies, the formula for Coca-Cola, recipe for Krispy Kreme donuts, some baseball rubbing mud, which I wasn't familiar with until I researched this presentation, and the formula for WD-40. So those are just some of the more well-known trade secrets that have not been disclosed to the public. And that's actually the reason why trade secrets don't come up in the academic context much, is because you have to keep them secret. And when you work for a university, typically you want to publish, you want to present, you want to share your research results. So that's why my office doesn't see trade secrets very often. So why is intellectual property important? First, it creates a lot of high-paying jobs. IP-intensive industries employed over 45 million Americans and hundreds of millions of people worldwide. Intellectual property also helps to drive economic growth and competitiveness. America's intellectual property is worth about $6.6 trillion, which is more than the nominal gross domestic product of any other country in the world. Intellectual property also helps to protect consumers and families. Enforced IP rights ensure that products are authentic and that they're high quality, that consumers have come to know and expect. Intellectual property also generates breakthrough solutions to global challenges. You're seeing it right now with the COVID-19 pandemic and the race to create a vaccine. You have to bet that intellectual property is involved there. And finally, intellectual property encourages innovation and rewards entrepreneurs by giving inventors a limited monopoly in the form of a patent, meaning no one else can practice or use that invention without their permission for a period of years. That incentivizes the inventor to keep creating so that when they're done benefiting personally from the invention, it can be shared with the public. So now I just wanted to touch on a couple career paths in intellectual property that I thought maybe some of you might be interested in hearing more about. First, of course, there is the patent attorney, and there's really two roads to becoming a patent attorney. The more traditional one is you would get your bachelor's, master's, possibly PhD in a scientific discipline. Could be engineering, physics, chemistry, biology. Anything scientific or technical pretty much would count. And then you would go to law school. So that's an additional 3 years of your time. It's a long road. And then once you graduate from law school, you would have to sit for the bar exam in the state in which you want to practice. So if you're planning to stay in Florida, you would take the Florida bar exam. And then you would also have to take the patent bar exam, which is a national bar exam that's administered separately from the state bar exams. So that's a long road, but at the end of it, you would be considered a patent attorney. You'd be able to draft and prosecute patent applications, or if you're interested in litigation, you could litigate patent infringement disputes. The second way to become a patent attorney, which probably won't apply to any of you, but applies to me and applies to other people out there, is that you would go to law school first. Maybe when you were in college, you didn't major in a scientific or technical discipline. Well, after the fact, if you go to law school and pass the bar exam like I have, you can go back and take additional classes in a scientific or technical discipline. And once you have the requisite number of credits, then you would be eligible to sit for the patent bar exam. So I'm hoping to take the patent bar exam this summer. The second type of career that's typically seen in intellectual property is a patent agent. So you can do most of the same things a patent attorney does, except you don't have to go to law school. So it could save you some time and some money. Typical requirements are that you have at least a bachelor's, preferably a master's, or even a PhD, again, in a scientific or technical field. But you still would have to take the patent bar exam. You don't have to take a state bar exam like an attorney would, but you do have to take the patent bar exam. So you would have to study for that and sit for that. But once you pass, then you would be able to do anything that a patent prosecution attorney could do. You could draft and prosecute patent applications. You wouldn't be able to litigate because that's reserved for attorneys. And then the final type of career in intellectual property that I wanted to mention to you that might be of interest is as a patent examiner. So you could go and work for the US Patent and Trademark Office on its own. Again, the requirements are pretty similar to a patent agent. You don't have to be an attorney. You just have to have either a bachelor's or a higher degree in a scientific or technical field. And then you would be assigned to work in that field for the patent office and process all of the patent applications that come in and determine if they're eligible for a patent. So those are just a few ideas if you're interested in possibly working in intellectual property, some of the things that you can do. And then these are just a few additional resources for you. If you are interested in any of the things I've talked about today and you want to learn more, I recommend going to the US Patent and Trademark Office website, uspto.gov. They have a lot of great webinars and other resources on there for you. If you want to learn more about copyrights, you can go to the US Copyright Office website, which is copyright.gov. And then if you're interested in learning about protecting intellectual property on an international scale, you can go to the World Intellectual Property Organization website, which is wipo.int. And with that, I'll say thank you so much for your time. This is my contact information. You're welcome to reach out to me with any questions you have, and I will turn it back over to David if anybody has submitted any questions.
So yes, we have a number of different questions throughout the presentation. So the first question that we had is that what are the costs associated to submit an application? This was around the time you were talking about patents.
Excellent question. Yes, I should have mentioned that. So when we're talking about a provisional patent application, that's the one I mentioned as kind of a placeholder, and it's only good for 1 year. That can cost anywhere, I'd say, from $1,000 to $5,000 to file. When you get to the non-provisional stage, that's a little bit more labor intensive for the patent practitioner to draft. That'll probably cost somewhere between $5,000 and $10,000. Then there's also costs associated with the patent prosecution process. And if you're interested in protecting your invention in multiple countries, you could expect to pay somewhere of an additional $10,000 per country that you're interested in. So the expenses can add up pretty quickly.
Thank you. So how many times can you apply for one of these provisional patents? For the same thing?
So sure, I understand what they're asking. It really depends on your particular circumstances. But it is possible, say you file a provisional application, it's coming up on the 1-year expiration date, and you're not ready to move forward. You still want to do more research, collect more data, et cetera. What you can do is work with your patent practitioner to file a second provisional before the first one expires. That's an important point to remember. You want to file before the first one expires. And that'll continue to give you protection. The only thing is that you will lose your priority date. So say you filed the first provisional application on January 1st, 2020. It expires on January 1st, 2021. You could file a second provisional, say on December 31st, 2020, but then you're only protected as of that date. So you wouldn't have protection going all the way back to January 1st, 2020. So that's a drawback of that strategy.
Thank you. So there's another question, is that how many inventors can be included on a disclosure and how many claims can that disclosure have?
So I just wanted to distinguish two things. So when you're talking about a disclosure, you might mean an invention disclosure, which is a form that's submitted to my office or the equivalent of my office to evaluate if the university or the company or whoever wants to protect the invention. So when you submit an invention disclosure, you can have an unlimited number of inventors. When you're talking about the patent application itself, if there's a limit to how many inventors or how many claims you can have. I'm not aware that there's any limit to the number of inventors you can have on a patent application. I don't think there is, but you want to make sure that the people you list as inventors are in fact inventors, and that term is legally defined. It's someone that contributes to the information that's contained in at least one of the claims of the patent application. So say you're working with an intern and you're just instructing them to copy some data into a spreadsheet. That wouldn't make them an inventor, because you're instructing them what to do and they're not really creatively contributing. So you want to double check to make sure everyone you list as an inventor on your patent application is actually an inventor, as it's defined by the Patent Office. And in terms of the number of claims you can have listed in a patent application, there's no limit, but I think after 20, you start to incur additional fees with the Patent Office. So you can have more claims, it's just going to get more expensive.
Okay, cool. Thank you very much. So another question is, if you have a discovery that occurs with a colleague, what sort of considerations need to be made in that situation?
So it depends where you're working. There may be different policies involved, but I'll just speak from the FAU perspective. In terms of I'm sorry, I lost my train of thought. Could you repeat the question? I got distracted by the chat.
Yeah, sorry. The question is, if you make a discovery with a colleague, what sort of
Okay. Yes. Sorry about that. So if you invent something with a colleague, say you're at FAU and you're two faculty members researching something together and you jointly invent it, the main consideration you're going to want to have is what the percentage contribution is between each of you, meaning, did you each put in 50% effort? Was it more 90-10, 60-40? And you're going to want to list that on the invention disclosure that's filed with my office, or if you're not at FAU, with the equivalent of my office. And that's important for us to know, because if your invention is ever licensed and royalties start to come in, those royalties are going to be distributed based on the percentage contribution that you and your co-inventors have agreed upon. So if you think you both deserve an equal split of any royalties, then you would say 50-50 or agree to some other arrangement.
Cool, thank you. Another question is, I don't know what these acronyms are, but can PCT be filed before a USPTO application? And if so, what would the advantage be?
Yes, so we use that strategy on a fairly frequent basis here at FAU. It helps you keep your options open if you're not sure where exactly you're going to want to protect the invention, if you want to license it to different companies and you're not sure where the companies are going to want patent protection. You could file a PCT application first, and there's two phases to the PCT application. The first is the international phase. That lasts about 30 months. It's examined by an international authority. But then after that 30-month period is the national phase, where you are required to elect specific countries that you want patent protection in. You don't get automatic protection in every country in the world. So basically it would buy you an additional 30 months to kind of figure out where you want patent protection. So that could be a good strategy.
We have this is a fun question. Can you share any stories of success that you've personally been involved with? And on the flip side, have you had any stories where somebody lost out because they didn't disclose?
Well, if they never disclosed it to my office, I never heard about it. So I don't have any stories like that. but it's their loss. I should mention at FAU, all of the services we provide to faculty, staff, and students from my office are free to them, and that's the case at other universities as well. So it's a good thing to take advantage of if you're in that situation. In terms of other success stories, we just got a patent issued last week for an autonomous vehicle technology. So it's a very hot area right now. So I'm very hopeful that Elon Musk is going to call me up and ask to license the patent. That would be awesome. We've entered into license agreements with a host of healthcare companies for it actually wasn't a patentable technology. It was a copyright and a trademark for a healthcare assessment system called Interact. And it's basically a way for healthcare workers in long-term care facilities to evaluate patient care and monitor what's going on with patients. So that license agreement's been in place for a number of years now, and it's generated significant revenue for the university. So that's another good one. Outside of FAU, there have been a lot of big ones. If you're familiar with Gatorade from the University of Florida, that came out of their tech transfer office. And it's funny, that wasn't a patent or anything. It was actually the Gatorade trademark that made University of Florida, I want to say upwards of $1 billion by now. So that's been a valuable one. Out of Florida State University, they created a cancer drug called Taxol, which has made them over $300 million. And then maybe the most famous tech transfer success story of all is actually Google, because some of the creators of Google came out of Stanford University. So Stanford still gets royalties on Google.
Very cool. Okay, so let's see, another question is, say your student was to create a mobile app, is that something that is under, would you file a copyright for that?
So yeah, typically software is kind of a gray area. In limited cases, it can be patented, but in most instances, copyright is really going to be your only avenue of protection. So yeah, you could copyright the source code. That's a pretty straightforward process. You could also keep it as a trade secret if it's not something that you have to disclose, keep the code behind a firewall and just let people access it that way. But yeah, copyright is really typically the only applicable method of protection there.
Okay. Thank you. Just one, this is less of a question, more of a comment, but before we end the show, it's been requested that we see your contact info slide again.
Oh, sure. Yeah, I can share my screen again. Do you want me to do that now?
We'll do it, I think, at the end of the Q&A. So when you have a drug formulation, is that a trade secret? Is that something people use in the pharmaceutical industry to protect their formulation? Or how would you protect the drug formulation?
You can protect it via patent. I just did another presentation earlier this week to the Center for Molecular Biology and Biotechnology that focused on biological patents. So I mentioned that drug formulas can be patentable. The threshold requirement is that they have to be not just sufficiently isolated from their naturally occurring state, but they have to have enough scientific manipulation, I guess you would call it. There has to be enough human intervention to make it different from its naturally occurring state. So I gave a few examples like adrenaline, vitamin B12, insulin, things like that. Before 2013, you used to be able to patent as long as they were sufficiently isolated. But the courts have now changed the requirements for obtaining a patent in that area, and there has to be more scientific intervention than just merely isolating the substance. But it is possible to get a patent on that type of research.
Okay. And then when a pharmaceutical company actually develops their drug, is that a trade secret? Can that be put beneath that firewall as well?
aware. I would assume it's possible. I'm not aware of any prominent examples of drugs being trade secret. I think the difficulty there is that, you have to go through FDA approval. There's a whole regulatory process. So I'm not sure how well they would be able to keep it secret. So I'm not sure if that's a viable method of protection there.
Gotcha. Okay, so if an FAU student were to create a product, what sort of interests or rights does that student have, and what rights does the student have, and what rights does FAU have?
Sure. So any university has an intellectual property policy. You can find it on FAU's website. And it depends on the type of student you are. If you're an undergraduate student, the policy is that you own the IP you create and you can go and do whatever you want with it. However, if you're a graduate student, postdoc, faculty, staff, pretty much any other category, the university will have an ownership interest in the intellectual property you create here. And there's two deciding factors of whether or not the university has an interest. First, the IP has to be created in the field or discipline in which you're engaged by the university. So if you're a professor of chemistry and you invent something in chemistry, if you're a professor of chemistry and you write the great American novel, the university probably won't have an interest in that. So you have to be working within the area that the university hired you to work in. Or if you're using significant university resources. So if you're going above and beyond to use FAU space, facilities, equipment, other personnel, that would give the university an ownership interest in your intellectual property as well. And for more details, check out the policy.
And so you mentioned that a faculty member working outside of their area, that kind of makes things fuzzy, but can a student use your services to trademark something if it's not related to their studies directly?
So you're welcome to submit a disclosure to my office and we'll take a look at it. My office has a limited budget from the university in terms of how many things we can patent, copyright, trademark, etc. So we have to evaluate each one individually on the merits and decide if it's something that the university wants to pursue, but we're happy to take a look at it.
Okay. So can people come to your office to discuss ideas and discoveries that somebody might have, but they're not sure whether or not it's patentable or not? That's kind of.
Yeah, absolutely. I would say my door's always open, but not during a pandemic. You're welcome to email me or call me, and I'm happy to talk things through with you.
Okay, so would you primarily represent / safeguard FAU's interests regarding intellectual property created by somebody while studying at FAU?
I'm not sure I understand the question.
Yeah, that's why I read it word for word. So I guess the question is, would you primarily represent / safeguard FAU interests regarding intellectual property created by someone while studying in FAU? So I guess you're not the lawyer. You would not represent.
So I represent FAU's interest as far as intellectual property goes. Am I the attorney that's actually doing the patent drafting and prosecution process? No, we use an outside law firm to do that work.
Okay, so last call for any questions any of the participants have. It's a great job.
No, thank you so much. I appreciate all you guys tuning in.